You're welcome. The All Progressives Congress and President Bola Ahmed Tinubu of Nigeria may have to wait longer for a final confirmation and closure of their fate in office as the presidential candidates of the leading opposition parties, the People's Democratic Party, the PDP, and the Labour Party, the LP, Atiku Abubakar and Peter Obi, have respectively filed petitions against the ruling party and its candidate's victory at the Supreme Court. Atiku, who came second during the presidential election, filed 35 petitions, while Peter Obi, who came third, has filed 51 grounds in his petition for a re-evaluation of INEC's declaration of Tinubu as president of Nigeria. The All Progressives Congress and Tinubu's lawyers have about 85 grounds to disprove as the final stretch of the legal tussle on the back of the presidential election inches ever closer. Now, it's not just all eyes on the judiciary, it's all eyes on the Supreme Court of Nigeria as Nigeria awaits keenly to see how developments unfold. Well, joining me on the show tonight, we have Barrister Monday Mawah, he's the Deputy National Secretary of the Labour Party. He joins us from Nigeria's capital, Abuja, which is the seat of the Supreme Court. Barrister, thank you very much for your time.
It's a pleasure to be here again. Good evening to all listeners.
All right. We also expect maybe at some point to be joined by another legal practitioner, GT Ogunye. But the presidential candidate of your party, Peter Obi, and the party that came second, Nigeria's largest opposition party, the PDP, Atiku Abubakar, have filed a combined 86 grounds of appeal at the Supreme Court. They want the Supreme Court to nullify the judgment of the Presidential Election Petition Court, which sat at the Court of Appeal, which affirmed Bola Tinubu's victory and his presidency of Nigeria. Kindly elaborate, at least from the point of the Labour Party, the key grounds and the arguments presented in the appeal to the Supreme Court.
Well, I think I will quickly make something clear that I'm not part of the legal team for Labour Party. And also, of course, I've ordered for a copy of the notice of appeal filed on behalf of our party today. And by the grace of God, before this time tomorrow, I should have a copy of it. But what I can also say for a fact is that our party feel dissatisfied by the judgment of the Presidential Election Petition Court. We don't call it tribunal, it's the Petition Court, because it's the Court of Appeal that sits as a court of persistence in respect of presidential election dispute. So our party feel dissatisfied with some area. The candidate, His Excellency Mr. Peter Obi, who happened to be the candidate, also feel dissatisfied with some area as well. And of course, the People's Democratic Party and their candidate, Haji Abubakar Atiku, also feel the same way. And they have filed or indicated their interest to appeal that judgment by lodging a notice of appeal. And of course, that of our party lodged about 51 grounds of appeal to contest the fact that the party is not satisfied with the judgment of the court. So I think that is the major thing. And what I can say is that the right to appeal is the right of every party. Thank God, what we have in Nigeria is that we have Supreme Court as the court of final finality. And so once any of the other court gives a decision or reach a finding in any issue or dispute, and you are not dissatisfied, you have the right to appeal up until you get to the court of final finality, which is the Supreme Court. And of course, that is where we are now. And from, I think the first ground I saw from what the friend has sent to me so far, we are actually, the party is contesting the issue that the Court of Appeal, sitting as the court of persistence, said that the party did not make a specific allegation on the area that the party feels they were rigged out in the election, because the party challenged some issue of irregularity in the conduct of the 2023 presidential election. And then there were some states that were highlighted, like Rivers, like those states like Delta State and some few other states. And the court said the court said that the party did not specify the area, the unit where they feel those irregularities took place in particular. That you cannot just come and generalize your allegation of facts. That's why in filing a petition that you must specify the area you are talking about, not just say, oh, there were irregularity in Edo State, there were irregularity in Bayelsa State. That no, beyond those allegations, that you must be specific. Which of the polling units, which of the ward, if need be, that you are dissatisfied with. And so I think that is, and the court was, those were part of the finding of the court. And we said, having laid some evidence, some documentary evidence alongside our petition to show the court the area that the party feels aggrieved, that the court, the party on his own part as a petitioner had discharged their onus and have discharged their burden. Because in election petition, as long as there is no criminal infraction, there is no criminal allegation involved or in contention, you are not expected to prove the case beyond reasonable doubt. It's the duty on you as a petitioner is to prove on the balance of probability. And probability is not a proof beyond reasonable doubt like we have in a criminal trial, where the state has a duty to prove the case against the accused beyond reasonable doubt. But in election petition, as long as you are not alleging issue of criminality, if it is issue of irregularity and all of that, you don't have a duty to prove beyond reasonable doubt. And we are saying the contention of the party is that whether the petitioner and the party who also happen to be a co-petitioner in the petition, that the party has discharged its onus. And so those are, I think that's one of the grounds I have seen so far. But by tomorrow, I'll have a full ground. And also, I think another area I saw again was where the court was also talking about the issue of the expert witness, in which the party brought in through subpoena. And of course, you understand that when you talk about subpoena is only granted by court against or on a party that is to come and testify before the court. In other words, you cannot, a subpoena can never be issued before the petition is filed. It is when the petition is filed and that the panel has commenced sitting that the court can sign, because the court must sign a subpoena before it can be served on a party that the court is calling upon or compelling to come and testify or to come and produce a document before it. So our party contention on that is that you do not expect the party to have been able to bring a subpoena witness statement on oath alongside the petition. Because before now, on the authority of the case of Mimiko, you are allowed to bring a subpoena witness outside the 21 days allowed to file a petition. But of course, like we used to say, that the law is dynamic and it's changing, and it changes almost on a daily basis, if not even on an hour basis. So, but the Court of Appeal, sitting as a court of first instance, heard that those subpoena witness that their written statement were brought in outside the 21 days allowed by the Electoral Act, within which to file a petition, are deemed that cannot, their statement cannot be admitted. And that was one of the major grounds upon which the court dismissed or rejected the statement of 10 out of 13 witnesses called by the Labour Party and its presidential candidate. So I think those are part of the area that the party is trying to settle it out before the Supreme Court. And the party is telling the Supreme Court that they are dissatisfied with some of those areas. I think those are just some of the little information in respect to that at the moment that I can dish out to the public.
Okay, interesting. We'll look at some of those details as we go on. But we all know that Obi has filed his appeal challenging the lower court judgment. He's asking for the entire, judgment to be thrown out by the Supreme Court. I think one of the issues you raised was the issue of making specific bring specific details if you say there were irregularities in polling
Yes.
units. The appeal court asking, presidential election petitions court asking the Labour Party to tell him you must show us polling unit by polling unit where these
Yes.
irregularities occurred, especially when it comes to overvoting. And they cited the famous or infamous case, whichever side you're on, of Wike versus Peterside that produced yes Wike in 2015. And that is his Supreme Court pronouncement. That judgment by the Supreme Court is on record. Is on record. And if we look at what happened in that case, since the Supreme Court has already ruled on it, do you think that Obi has a chance to convince the Supreme Court that the earlier judgment in 2015 was wrong?
Now, you see, every judgment or every case rather is treated on its own merits. No matter how similar two cases may look like or may appear, they can never be the same. So what, as a lawyer, and what the judge and the lawyer will look at is that beyond the fact that, oh yeah, something was decided in River State, you will now begin to look at it. What was the circumstances in River State? First, it was not in relation to presidential election. That is one. Two, the area covered for River State it was quite different from the area covered in the 2020 presidential election. And also, we now have a new electoral act 2022, which was not applicable as far back as 2029, because the River State case of Wike and Peterside, River State is always a very famous state, because I can still recall there were issues in 2015, and then they were also issued in 2019. So 2015 was more, because in 2015, the tribunal sacked His Excellency Yesu Wike. Then the Court of Appeal affirmed. But it was at the Supreme Court said no, because the issue then at 2015 was that the INEC officials, they did not comply with the INEC guidelines and directive or regulations in computing results, that they were some of those things that they computed, they did not follow the INEC rules and regulations. The tribunal agreed with them. The Court of Appeal also agreed with them. But by the time they got to Supreme Court, the issue the Supreme Court was faced with, some of the questions the Supreme Court have to resolve then was that when there is a conflict between the Electoral Act and the INEC timetable or INEC regulation made pursuant to the Electoral Act, that we supersede. And the Supreme Court was emphatic in that judgment that once there is a conflict, yes, that notwithstanding that they let the INEC rules and regulation or INEC derive its power in making its rules and regulation from the Electoral Act or the Constitution, that when there is a conflict, the regulation must bow to the Electoral Act, that the Electoral Act is superior to the INEC guidelines and regulation, and that once there is no specific provision for a particular way of doing an act under the Electoral Act, but the guideline provide for it, INEC regulation and guideline provide for it, that the guideline cannot supersede. So as long as it's not in the Electoral Act, that the guideline is only meant to be directing to INEC in the conduct of its duty as an electoral umpire. On that ground, the Supreme Court set aside the concurrent finding of both the tribunal and the Court of Appeal. And that was how Wike was returned as the governor of River State. And that was why I was saying earlier that issue of River State is very famous. Now, of course, 2019, some other issue arose also in River State, but it was not that famous as that of 2015. But the point I'm trying to make here is that we have a new Electoral Act, which was passed into law in 2022, which is now cited as 2022 Electoral Act. There are some of these new rules and regulations that were not applicable as at 2015 or 2019 that are now here. So the point is this: the Supreme Court, looking at the 2022 Electoral Act, may decide to see things differently now, because like I said earlier, the law is progressive. And like Lord Dennis in his famous statement said, He said, what is the argument of the other side? That is it that only it has not been done before? He said, this argument does not appeal to me a little, or at least. He said, because if we fail to do that which has not been done before, that the society will move ahead of the law, and the law will remain on the stance, on a standpoint. Okay. And that will be dangerous for both the society and the law, because they are supposed to move pari passu. So the point is that the society has moved beyond what it used to be in 2015 and 2019. And I know the Supreme Court will take all of those changes into account in coming into whatever decision they will take in this appeal before them.
Let's stay with Labour Party for a bit. Though you're not of the PDP, but I'll take your thoughts on that at some point. The tribunal also found that Obi and Atiku and other petitioners, the APM, failed to substantiate the allegations against the election conducted by INEC. So one of the things that they said about INEC was that the onus of a proof that INEC erred in law, or so that INEC failed to comply with the mandatory requirements of the Electoral Act, was on the petitioners. And in this new, fresh grounds of appeal to the Supreme Court, what your party and its candidate will be in ground 7 is saying is that they're saying the justices affirmed or erred in law, rather, and occasioned a grave miscarriage of justice when they held that the onus was on the appellants to prove that the first respondent in their petition at the PEPC, INEC, failed to comply with the mandatory requirements of Section 73, Sub 2 of the Electoral Act and the conduct of the presidential poll. Obi is saying, your party is saying, your candidate is saying, that the tribunal overlooked the fact that the chairman of the first respondent, INEC, is the officer in lawful custody of the election and electoral documents, which the appellants, your party, applied for within the meaning and contemplation of both the Electoral Act and the Evidence Act. So what are your thoughts on this? You know, because the petition says, and I quote, despite the service of subpoenas on the first respondent, INEC, the first respondent still failed to produce the election documents up to and until the conclusion of proceedings in the trial court.
Yes. Well, I will not want to sit here as like an appellate court over the judgment of their very learned justices of the Court of Appeal. But it suffices to say that there is a law which is trite. And when we say something is trite in law, it means even a 100-level student understand that part. It is notorious. When we say something is trite in law, it is notorious. It is in commonplace that if there is a piece of evidence in your custody and a lawful demand was made for the production of that piece of evidence, and you who has the custody of that document refuses to avail the document, the law is that it is presumed that if you had produced that document, it would have been used against you. We call it withholding of evidence. And when you are found to be withholding a piece of evidence, the law will presume it against you and found in favor of the other party that has made the lawful demand. And of course, that is a very solid ground that the party has also made.
But you're saying it's solid. Is it watertight, though? Because we saw that there were some loopholes at the PEPC.
It is tight. But of course, we now wait for what the Supreme Court will make out of that. Because like I said earlier, that is a notorious law that even up to a 100-level student, that is one of those persons you will know. That when there is a piece of evidence in your possession and you fail, and there is a demand for it, and I use the word lawful demand for it, and you fail to avail demand that has demanded for it. If it's something that you are supposed to pay for, if the man has paid, if it's something you must apply for through the court, if the man has lawfully applied, you now have an obligation to produce it. And if you fail to produce it, it will be presumed against you. And that evidence will be resolved against you. Now, there was an ex parte filed by our party, which the court also granted, compelling INEC to make available to the party some certain document that the party was to use to prosecute the election petition. But of course, not more than 2 occasions, the party had to complain to the court that INEC had practically withhold this document, which are very relevant evidence that were to be used. But of course, along the line, one way or the other, till the end of the petition, none of those documents were made available. Let me not use the word none. Out of 100%, I do not think the party was able to get up to 30%. And this is an election. You are supposed to use all of those documents, those evidence to establish your case. And so, with the greater respect to the learned justice of the Supreme Court of Appeal, what ordinarily I would have expected was that the failure on the part of INEC to produce those documents ought to have been presumed against them, and that aspect resolved against INEC and in favor of our candidate. But somehow, somewhat, that didn't happen. But of course, we are human, and they're human enough to make mistakes, and that is why we have the Supreme Court there.
Okay.
And don't forget, this court of first instance, they were three learned men that sat over it. At the Supreme Court, there will be 7. So they will we have opportunity of having 4 additional brains that will look at the whole thing.
Monday, before you go, final one. The prayers or the remedies that are being sought by these individuals, Atiku Abubakar of the PDP, the other party in your case, is seeking various remedies, including the declaration that he, Atiku, won the election, or in the alternative, that a runoff be organized or be ordered between him and President Tinubu. And your party is basically challenging the conduct of the election and asking for the cancellation of that election, probably for fresh elections to be conducted. I'm not sure if your party is asking that Obi be declared winner. Just your thoughts on the 2 different prayers of APC and LP, finally.
Well, like I said earlier, as similar as the both cases may seem, the PDP as a party has its case distinct from that of Labour Party. Of course, what they are both asking for, no matter how similar also, there are some other the similar thing in what they are asking for. Of course, the Labour Party is asking outrightly for it. That's the way our position earlier was that the court should declare the candidate as the winner. But of course, Atiku is asking to also be declared winner, or in the alternative that a runoff be declared. Now, they both have the right to demand for whichever one they feel suit their case. But at the end of the day, like we say, that when the chips are down, the prophecy of what the court will do and nothing more pretentious. That is what the law is. So, irrespective of what both parties are acting at the end of the day, it is what the court eventually decide that is decided eventually. Between the matter between them, that is what is going to be.
Monday, but Mawah, thank you so much for your time. This issue is not yet exhausted. There's a lot more to talk about, and we'll keep our eyes on this story. Monday, Mawah is a legal practitioner and, of course, Deputy National Secretary of Nigeria's opposition Labour Party. Thank you for your time.
It's a pleasure. Thank you.
So watching Politics HQ, we'll be right back. After this break, we'll delve straight into the politics of Kano State, where they're having their own tribunal ruling or judgment. It's a ripple and an earthquake in Kano politics today. Stay with us.